Okay, we will now convene the February 13, 2024 Special Magistrate Proceedings for the City of Daytona Beach. At the outset, I've reviewed and approved the January 9, 2024 minutes. Do we have any announcements before I start into this morning's agenda?
Yes, sir.
If I could just clarify, since we do have two agendas, so we can just make reference to each one specific. We have the Ninth Week Master Plan Appeals, which is one agenda, and the other would be the standard Special Magistrate Code agenda.
Yes, sir.
So I have some announcements for the regular special magistrate meeting. Sorry. The special magistrate, the regular special magistrate proceedings, I have a couple announcements. On page 4, case number 11, SMG 02-24-49, Rose Avenue parcel is in compliance 2/12/24. Page number 9, case number 29. Do I need to? Just 1 minute. going to skip that one for now. Page, never mind, that's it. I'll do the other two as they come in order.
Will those representatives for the city of Daytona Beach who will be testifying at this morning's proceedings, please stand and be sworn?
Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth? Thank you.
All right, the first order of business today is going to be the appeals regarding the Bike Week Master Plan. First case, Brook Cleaners, 133 Main Street. Is there anyone here for the respondent?
Go ahead and come up to the...
Yes, sir, if you would please state your name and be sworn.
State your name.
Apura Masrani?
Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes, I do.
Thank you.
Okay, just so we can move this along, it would appear as though your request to participate during the 2024 master plan activities was denied for lack of a business tax receipt.
Yes,
It expired, missing proof of ownership documents, and a missing parking layout. It's my understanding those documents have now been provided. Is that right, Counselor?
That's right, Mr. Kelger. That's correct.
Okay. So I'm assuming with that, he satisfies all the other criteria to participate in the Bike Week activities?
No, that's correct. He would satisfy the criteria, Mr. Kelger. The circumstances that once he's not recommended through the master plan and accepted at the commission, then he would need to come before the magistrate to seek an appeal, and that's what he's doing. And in the interim, he's taking care of the deficiencies, and so we acknowledge that, and we bring this before you just with the understanding of and recommendation that's the criteria alone, which is the consideration of the magistrate and solely the magistrate's review. And that criteria is that it's in section 5.4.c.11 of the Land Development Code, and it says under that subsection, where the applicant is an individual, the fault of a waiver may only be granted for just cause based on the following considerations. Where the applicant is an individual, you look at the fault of the applicant in creating the condition that led to the order or the denial. Where the applicant is a corporation, basically you do the same thing, or a limited liability or a similar business firm. You look at the firm's principles, fault in creating the condition. Then you look at the gravity of the violation. And lastly, any prior opportunity that the applicant had to remedy the condition. And if you elect, you could set conditions for the approval if you feel that's necessary. When I say if you feel that's necessary, specifically what it says, with additional requirements determined to be helpful or necessary in maintaining health, safety, and welfare.
When did you acquire Brook Cleaners?
so it's owned by my cousin, and it's been more than 15 years.
More than 15 years.
Yeah.
So you're familiar with Bike Week on Main Street.
Yes, sir.
So why was the application in?
So it's just a misunderstanding. Like, we do this every Biketoberfest and Bike Week. So I do the application all the year, like twice in a year. But this time it was different. So we misunderstood and we were failed to submit the documents. But later, when we came to know that we have to submit the bike plan, the layout, everything. So I worked with the city official, and then I submitted everything.
Okay. And what sort of hardship would it present to Brook Cleaners should this application be denied?
Sorry?
What kind of hardship would Brook Cleaners be looking at should this application be denied?
Yes, sir. Like it's a great event where we can help. Like we just do the parking for the cars and the bike who want to attend the meeting. We don't do any retail business or anything. We just do the parking.
You don't do any retail business there at Brook
I
Cleaners?
mean, during the bike week,
Right, you do outside
right,
retail.
outside, just the parking, car and the bikes. That's it.
Car and the bikes and the retail outside business.
Right.
Okay, so I assume those are important to your business.
Yes, sir.
All right. And I assume that if you were deprived of that income, given your technical violation of the application process, that would pose a hardship for Brook Cleaners.
Yes, sir.
Okay. I'll go ahead and grant your application.
Thank you.
Okay.
Is there anything else that's required? And if anyone else wants to be heard, please speak up. Oh, I'm sorry.
Good morning, Rose Askew, Bike Week manager. I manage the Bike Week process. Part of the reason we had people that had to do appeals, the city commission directed staff to add some additional criteria for things that are needed for us to for them to be able to adequately review it and approve it. And I think some of the participants were just a little bit confused about it. And so what we did was we gave an extension all the way up till January 5th for everyone to turn in their things. So the deadline ended in November of last year. We extended it all the way up to January 5th when we had our public meeting. And at that public meeting, we even stayed there until 11 to allow people to turn in their documents. We had like 32 applicants, and these are the only 4. And I do understand Mr. Patel's issue. He has been turning in the same kind of layout for 15 years, and now we've changed it. And he was just a little bit confused about why he was not able to continue to turn in. So I have worked with all 4 of the applicants to make sure that in the future coming forward, they will all know what is required for them to be able to get their application approved and not have to come to the magistrate.
Okay, thank you.
You're welcome.
Well, you know, I sit here day in and day out, and I listen to all kinds of people coming before me trashing the city of Daytona Beach. By all means, you and your other 3 compatriots that I'll be hearing from in a minute should take every opportunity you can to let everybody passing through your doors know how gracious the city of Daytona Beach can be to its citizenry, especially when it comes to trying to assist them in continuing and enhancing their business opportunities.
Thank you.
Your application's granted. Good luck to you.
Thank you, sir.
Case number 2. And, case number 2, Made in the Shade, 34 North Halifax Avenue. Anyone here for the applicant?
Nope.
Ms. Askew, if you, I need you to testify here. Ms. Vikelja, I'll ask Ms. Askew to express to you, but what she's explained to me is that she made sure that she told every applicant that they had to be here, and she does not know why this applicant isn't here. Without the applicant not present, she will acknowledge the same information that's been presented to you, which is that they have completed their deficiencies. However, we'll leave it to your consideration discretion on what to do going forward. We're not in a position to make a recommendation in their absence, and we wasn't making a recommendation anyway other than to inform the magistrate as to the issues regarding this appeal. I would ask Ms. Askew if there's any other issues. If you can come forward, Ms. Askew. You can come forward, Ms. Askew.
Is it Ms. Askew?
Yes, sir. Yeah, as I said before, all 4 applicants have met the criteria from the Bike Week Master Plan and the Land Development Code criteria. They were all notified that they needed to be here today to represent themselves to speak on why their documentation was late. I was not aware that any of the applicants would not be here today. So, I mean, he didn't show up.
So, let me make sure I can put this in perspective. This fellow's application was denied because he failed to comply with the formalities.
That is correct.
And then you indicated to him we would be inclined to accept it were he to show up here.
That is correct. They all
He
in the
has now failed to attend.
correct. In the documents that you all have, it shows where we sent them the notification that the magistrate meeting was today on the 13th and they needed to be here.
Okay, denied. And Ms. Askew, I understand everything you've done, and I appreciate your efforts. You're welcome to stay and be called back up here if Tony feels the need, or I think I already understand what you have to say, whichever you prefer. Case number 3, Cressman, 344, Dr. Mary McLeod, Bethune Boulevard.
Warren Traeger,
Good morning.
Bostic Avenue.
I'm Ruth Traeger.
Good to see you.
Can you raise your right hands? Raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes.
Thank you.
Well, I know I don't have to impress upon you how gracious the city of Daytona Beach can be to its business persons. So that having been said, okay, apparently you failed to do a few things. It's my understanding corrective action's been taken. And that having been said, just so I can do my job, would you please articulate for me what the hardship would be you would be subjected to were I to do something other than approve your appeal?
Would definitely be a hardship.
You can articulate a little more than that, can't you?
Yeah.
Okay, feel free. Here's your
It would,
opportunity.
our revenue would be way down.
Okay.
We've been doing this for over 30 years. Never had a problem before. And all of a sudden, came up with something new.
Yeah,
We got the permit. It's the county, RV
Park.
got one, yeah, but it's county permit. We never had to have the county permit before.
okay.
And if you want to hear the long version of it,
No, I don't want to hear the long version. What I'm really curious about is what do you do out there on Mary McLeod Bethune Boulevard
it's RV,
during Bike Week?
RV park.
RV parking, okay.
Yes, sir.
And I assume that's an income source for you?
Yes, sir.
Very good. All right, I'll go ahead and approve the appeal.
All right, thank you very
And
much.
good luck to you.
Thank you.
Case number 4, 12 North Halifax. Anyone here with regard to 12 North Halifax? Okay, is there anything I need to know about 12 North Halifax that I don't know about already, other than their absence? Denied. I don't mean to be unfair here. I just anticipate these people calling and bothering you. Do we have any idea why they're not here?
No, sir, I do not. And I spoke with them last week to make sure everyone was aware they needed to be here today. So I don't know why they're not here.
Can I defer to Ms. Askew the authority to allow these people to participate in the event they surface, which I expect they will, because she would be infinitely more qualified to make that determination than I would. And they might present to her some extenuating circumstances that might explain why they're not here right now. I'm just asking if I would even be permitted to do that. And I'm really not trying to rewrite ordinances here. If I can't, I can't.
Yeah, no, hold on.
If you defer, it would be to the city manager to make the final decision.
Okay. All right, then I'll tell you what I'll do. I'm going to deny their appeals. And I don't mean to sound too lawyerly here, but I think everyone will understand what I'm talking about. Without prejudice to them taking the matter up with the city manager, should he choose to reconsider my denial. Is that fair enough?
I'm thinking, Mr. Calger, that perhaps we may want to do it by making it a conditional approval upon the acceptance of the city manager. Only because you have the authority granted in the master plan to grant with conditions.
Okay. And
So
what do you want me to say? I'll approve the appeal subject to the city manager's approval?
if all other information, had they been present and said the right things, would likely lead to an approval, seeing that they have at least remedied their deficiencies.
Now, am
then
I
you-
going to aggravate some city manager because I'm delegating back authority I'm supposed to be administering right here and now?
Well, I'm a little
I'm
uncomfortable
really
about it
not
only
trying to
because I
pass
have
the
it.
buck. I'm trying to accommodate some businessmen, and I'm hoping they've got some serious extenuating circumstances for not being here. Because if I were denied an opportunity to participate for failing to comply with the rules and regulations, then I failed to show up at the hearing for my appeal.
I think what you said initially would pass muster on appeal, so I'm okay with that as your ruling. If that's how you elect to say it, it's fine.
And then the other thing is, I ain't going anywhere. You can pick up the phone and call me if these people surface and want to be heard. So tell me how you want to handle it. I'm just trying to lighten everyone's load here.
We'll go with your initial announcement of denial. And
I'll deny it
Without
I will
prejudice.
deny it without prejudice to the city manager's reconsideration.
I'm good with that.
That's what I'll do in both of those instances. Very good. Thank you, ma'am. All right, case number 1, Ivan and Carden LLC, Tammy Tran, and Social Daytona Incorporated. Anyone here for the respondent? Not seeing a respondent, what say the city?
Before we move forward, I believe I was told that maybe on Zoom.
Yeah, she's supposed to be on Zoom.
Number 1 is on Zoom, okay?
Should have 2.
I've got to see if they are on Zoom or if we're working on that. Yes, we're coming up right now. Okay, thank you.
While he's doing that, you were talking to me earlier like I should know this property. What is 631 Grandview?
Yes, that's the property was before you last month for a violation of the after-hours.
Yeah, the allegation was serving, that they were at that time serving alcohol after hours.
What's the building?
It's a building across from the Gentlemen's Club there on
Okay.
North Grandview, next to a pizza
Gotcha.
parlor.
All right, now I know the neighborhood. That's all I needed. All right, we have a couple people appearing by Zoom. Folks, if you would please state your names and be sworn by our secretary.
My name is Tammy.
Ma'am, what's your full name?
Oh, Tammy Tran.
Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes.
And you, sir? Sir?
Are you asking me?
Yes.
Yeah, good morning. This is Kevin Vagovic. I'm her attorney.
Okay, thank you.
Okay.
You're welcome. Sorry.
Ms. Tran, do you agree this violation existed or occurred as stated in the notice of violation?
Yes, sir.
All right, then I find the respondent in non-compliance. Let's hear.
Your Honor, I don't mean to cut you off, sir. This is not my client who's in violation. This premises is leased out to a third party who we're actively trying to remove from the property. We terminated their tenancy, and if they don't leave, we're going to institute an eviction action. But it's not my client who's in violation of any of the ordinances alleged by the city. It's the actual tenant. My client lives out in Texas.
Your client doesn't have a what?
She lives out in Texas.
Okay, well, I understand, but the property is owned by her, and we don't have any relationship with whatever tenants she may have. So as the property owner, she's responsible for what takes place on site. So now we'll take that into consideration. I've got Mr. Jackson here wanting to speak. Let's hear what the city has to say as we wind our way through this.
Yeah, Anthony Jackson, attorney for the city. One thing I want to do first is acknowledge that the city has received correspondence that indicates that Mr. Vagovic, that they've proceeded, and we've been able to verify that as well with notification. And I believe there's a filing. I'm saying we verified that. I don't know. I'd have to ask Mr. Vagovic, but that they were given a 3-day notice as well as a notice of violation of their lease, and that's now timely. I don't know if they've been proceeded since then. So we will acknowledge that. Our circumstance, though, and we have the officers here to present from the last meeting to this current date, that they've had subsequent events that occurred at the property, even with the strong expression of a need for it to stop from you, Mr. Magistrate. Law enforcement has gone in and they continued the same conduct that has been going on based upon the testimony at the last hearing, the type of conduct that has been going on since June of 2023. And as I said, we do have law enforcement to speak to that conduct, and I realized that the owner then expressed her limits of knowledge as to what was happening. However, the actions that were taken, we don't know when they were taken, and to now, to what extent have they continued in proceeding with the foreclosure. So if they could speak to that, I mean, to the eviction, I'm sorry. So if they could speak to that, we would, as I said, we're willing to acknowledge whatever is being spoken by counsel on that regard. But nevertheless, we do have these, and we did cite both the business owner as well as Ms. As well as the property owner. The business owner, yeah, the tenant. When I say business owner, I mean the tenant. So we cited the tenant as well as the property owner.
Okay, Mr. Vagovic, I assume your client is Ivan and Carden LLC?
Yes, Your Honor. Ms. Tran is the owner of that LLC, which owns the building.
Who is Social Daytona Incorporated?
That's the tenant?
That's the tenant.
Yes.
Now, I thought I heard somebody mention right at the outset that you removed the tenant?
We're
Yeah.
in the process, Your Honor. We sent them, as Mr. Jackson said, a 7-day and a 3-day notice, and I believe they're right now for filing, so I'm in the process of drafting the complaints and having them filed.
So right now, South Daytona Incorporated is still in possession of the property?
Yes, Your Honor.
And am I to assume that Ms. Tran is going to tell me it's Social Daytona Incorporated that's responsible for all the conduct that the city's complaining of?
Yes, sir.
Okay.
I would like to bring, if I may, Mr. Vacaljo, I would like to bring law enforcement forward. And our purpose is that we're getting a lot of complaints. We believe that this is a irreparable, irreversible violation. They're getting economic advantage of other businesses. The other businesses are complaining. They're doing something that's egregious, contrary to state law as well as our local law. And so we are asking for a fine. And so I'd like them to testify as to the circumstances.
All right, hang on one second. Case number 2 is this same respondent, same location, different violation. Is that right?
Yes, sir.
So am I to assume that the testimony I'm about here is probably going to cover both cases?
Yes, sir.
Mr. Vagovic, does it sound, is it your assumption the testimony in this matter is going to cover both cases? You are aware we have 2 different cases here against your client.
Yes, sir, that's correct. And in an effort to save time, we'll concede. If law enforcement wants to get up there and speak, but I've seen the police reports. We'll concede that there's been a lot of disruption and law enforcement presence necessary at the scene as a result of the tenant's egregious behavior. I mean, we'll admit that, everything's been going wrong. It's just our issue is that it's the tenants rather than my client who's causing the disturbance and violations of the code.
All right. Sounds as though the respondent's not going to dispute what law enforcement has to say.
Well, our problem or our concern is that if this was to take 30 days, we may have 3 more weeks of the same thing we've been experiencing every week, and
Well,
we believe we can experience every
If he
day.
hasn't filed his complaint to evict the tenant yet.
Exactly. And so,
Tenants decided to go rogue.
well, and that's why we would like to at least get a clear message to the tenants, even if it's not specifically to the owner.
I can convey a real clear message to the tenant. My question here is, I guess, what's the relief you're looking for?
Well,
What's the
we're asking for,
fastest whatever I can do here to try to ameliorate the situation that law enforcement's confronting?
well, this is right now what we have is a request for a fine of $15,000, which is the maximum for irreparable reversible. Once we have those things going forward, it may support whatever other actions we take. We've been getting warrants, we've been going in there, we've been finding even underage drinking situations through, and so there's a lot of things that are very concerning. So what we're looking for is what the statute provides for, and we seldom ever push to this direction, but the statute provides not only for liens that would attach to the real property, but also to be able to utilize his judgments against all personal property. And so at the very least, to have the consideration of attaching whatever personal property that's operating and utilized in this business. So our purpose is still to ensure that we're holding a tenant accountable, because ultimately, this is...
Hey, is the tenant been cited?
Yes.
Okay.
And ultimately...
And where's the tenant? Why isn't the tenant here?
That's what you just called and asked for. We don't have an answer to that.
Okay.
They've been cited. They've even been arrested on it, if I'm...
Okay,
on
well, I'm not
issues.
disputing that. I'm just trying to sort out what I have in front of me here. We have 2 cases, both involving 2 parties, one being an owner, one being a tenant. We have an aggravated city and a bunch of PO'd policemen. I understand all of that, and the owner's in agreement with that. So the 2 parties that are before me right now, one of them is agreeing with everything you have to say. Or it sounds like, I don't want to put words in their mouth, but it doesn't, I'm not hearing a whole lot of dispute. So I have no problem doing everything I can against the tenant right now, and it doesn't sound as though there's any dispute as to it being warranted, and I don't have a tenant here to defend myself, so the heck with the tenant. When it comes to the owner and the relief you're looking for, that might be a different matter. I just want to make sure everybody understands that, because, and I don't want to, anyway. So all that having been said, that's the lay of the land. Go ahead and put on your case.
Good morning. I'm Lieutenant Gerner with Daytona Beach Police Department. Since our last magistrate hearing on January 9th, Sergeant Blowers and I executed a search warrant on the 11th of January in the structure for sale of alcohol. We did find some alcohol in there, just they were hiding it in common bottles like cranberry juice bottles or soda bottles. We conducted another operation on February 4th at about 2 in the morning, where we sent in undercover detectives to enter the business, where they paid a $20 cover charge each to enter. They ordered alcohol, they ordered tequila, where the ownership of the business removed alcohol from a cabinet underneath the countertop, served them the alcohol, charged them $15 a piece per drink. They sat there for 30, 45 minutes and then exited, where we then executed a second search warrant. Included in that search warrant was the ownership's vehicles, where we found more alcohol inside the vehicles, because that's how they're transporting it, since they don't have a liquor license issued by the state, which would require them to have alcohol delivered to them through a manufacturer. We arrested all 3 owners that night for sale of alcohol without a license and for violation of our city ordinance operating without a after-hours permit. Since that search warrant on the 4th, they were open that following Thursday, which would be the 8th. They were open over the weekend after that. They were open even the weekend after January 9th's hearing. They've been open every single night since our last hearing, where you found them, where you found the owner of the business compliant or complicit in what was happening there. Ownership of the business, Social Daytona, the ownership does not concede to what is happening. They're not stopping. We prove it almost every single night. They're just doing what they want. Businesses in the area, especially Grandview Live, complain because they can't charge the same amount of money for the alcohol that this business is charging. They're losing business because of what's happening across the street. And several other businesses in the general area are also very upset and file complaints with us constantly about what's happening across the street from their own business, which would be at 631 North Grandview.
What is the business at 631 North Grandview, other than what you've just described?
They are listed as a hookah pub. They have a tobacco permit issued by the state of Florida. They do serve hookah. However, the fire marshal has gone in there and done an inspection, and they cannot sell hookah or smoke hookah inside because they don't have proper ventilation within the structure. However, they ignored that. I think that was in December 28th or 29th. The fire marshal came in to do a new rating of the occupancy within the structure, and that's how they discovered about the hookah being sold. Even with the hookah license, they still have to have the after-hours permit, which they don't permit, or they don't possess. Other than that, they're selling alcohol illegally. I've done an operation in there with an underage officer. She was 19. They sold alcohol to her then too, back in October.
All right, Mr. Vagovic, did you want to ask the officer any questions?
Your Honor, I don't think I have any questions for her. Thank you.
Okay. So this is supposed to be a hookah pub, and you're telling me the fire department says it's not even equipped to do that?
Correct. They're not. They don't have the proper ventilation for removing the smoke from within the structure. Like, there's another hookah pub down the street on Seabreeze at 502. They've complied with everything, to include the after-hours permit. Fire marshal's done everything they're required to do. They're actually in compliance. However, this business of Social Daytona is not.
Ms. McKelvey, we've been, if I may, we've been put in a position where we're having to go out with the knowledge that we can go every day and find this property in violation. We believe that there's an owner obligation, whether it's to get security locking that door or something, to ensure that these things aren't going on in this business. The owner signed off, authorized the applications that were made by this business. I would ask Ms. Askew to come and just, since we have two different cases. One is a land use violation, that's the first one, and then the second one is the violation of the after-hours permit. I would point out that the reason we cited a violation on the after-hours permit is not because they have one, but by our definition of an Article 3 of our Land Development Code, of our Code of Ordinances, Section 1 defines an establishment dealing in alcohol to include anyone, let's see, whether open to the public or at large, or where entrance is limited by cover charge or membership requirements. And it's where a product or article, sorry about that, a product or article is sold, dispensed, served, or provided with the knowledge and actual or implied that the product or article will be or is intended to be mixed, or commercial establishment, intended to be mixed, combined with, or drunk in connection or combination with an alcoholic beverage, so on and so forth. So they fit our definition, and it's a prohibition for them to be open after midnight, which they are doing, opening after midnight, even though they don't have a permit. So that's a prohibition for any business, as well as state law provides that if they only can be open until midnight unless they're authorized by a local government or county to open beyond that time, and they are not authorized.
With regard to the first violation, what is the appropriate development permit that we're talking about?
And that's what Ms. Askew will speak to, and she can identify
I mean,
that as well.
Sounds like they're not allowed to sell alcohol, and they're doing that. Is that a development permit?
Good morning. Again, Rose Askew, project manager for the city. Yes, in our land development code, it requires that prior to you opening and establishing your establishment, you have to pull all of the appropriate permits and make all of the renovations to the property that's required before you can open and operate. This business is operating like a nightclub. They're not they are not approved for a nightclub. They're not approved for a hookah establishment either. In our Code of Ordinances, it has very specific criteria for hookah establishments when it comes to the type of ventilation you have to have in the system, hours of operation. You can't be open past midnight unless you have an extended hours permit to serve and sell alcohol. This particular establishment has been serving alcohol without a state of Florida license. I checked. They do not. They have not even applied for a state of Florida license. So there's no way they could even get an extended hours permit. So no alcohol service should be done on the property. The way they are supposed to be operating is as a private club where they can have their members there and possibly be able to invite people. Their members may invite a person, but they're not supposed to be operating like a nightclub. There's no alcohol service that should be allowed on that property at all. And so the fact that they are purchasing alcohol from a regular store and keeping it in their trunk, when you have an alcohol license, you are required to purchase it from very particular establishments, and that information has to be provided to the state at the end of the year when you do your information, when you have to provide your taxes and stuff. So there's things they're doing that are well outside of the parameters of what the state of Florida allows you to do. You can't, as a business, buy alcohol from like a liquor store. You have to go to actual distributors for the alcohol because it has to be tracked. They can't do that because they have no liquor license. So none of the things that they're doing currently right now are what they got a business tax for. And I wanted to say business tax because that's exactly what it is. It's just a tax. It doesn't allow you to open and operate. You have to pull all of the required permits and develop the site meeting the criteria in the Land Development Code and the Code of Ordinances prior to you starting to operate. And I'm not sure what the property owner signed off for them on their lease, because it sounds like she's saying that's not what they signed off for them, but that is how they're operating. They are in violation of almost every single thing that they're doing on that property.
Okay, now that I understand what's going on, now we come back to one of my original questions. So what am I authorized to do, assuming we're dealing with an egregious situation, and this certainly sounds egregious, with regard to the owner? And what am I authorized to do with regard to the tenant?
Okay. First of all, I do want to say we appreciate that the owner is taking steps, went and got counsel, and is moving.
How long has this been going on?
This has been going on since June. Is it June? April. I'm sorry, April of 2023.
Well, then I'm not giving the owner a whole lot of credit.
And it's been repeated. We have.
Okay, you've
we've
answered
notified.
that. Let's get
Yes.
back to my question.
I'm sorry.
My question was, what's the extent of my authority, assuming this is an egregious situation, with regard to the owner and with regard to the tenant?
You're able to sanction both the owner, impose fines that would be applicable to the violator, as well as to as well as an encumbrance on the property. So your general orders generally would be an order imposing a fine against whoever the named violator or multi-violators and as against the property. So it will impact.
Find somebody at the same time that I'm finding them in non-compliance?
You can with a finding of irreparable, irreversible. And that's why we're bringing this as irreparable, irreversible, the first case. Now, in the second case, we're leaving it as a repeat violation. You did make a finding on that second case as to the same violation last time we were before you, and you gave a stern warning to the owner that they would be facing up to $5,000 fine per occurrence if these events continue to
When
occur.
did I do that?
At the January 11th? 9th, January 9th meeting. There you go.
Okay, Counselor, were you at the last hearing?
No, Your Honor, I was just retained 2 weeks ago.
Well, let me read you something here. This is from our minutes, from our January 9th meeting. Based on the findings and the testimony of the officer, the special magistrate ruled the case was in noncompliance, and based upon the stipulation of the city, he found that the respondent has since come into compliance, and for every future violation, the special magistrate will consider entering an order for a fine of up to $5,000 for each repeated violation. This was Ms. Tran being warned that for every future violation after January 9th, I would be considering the imposition of a fine of up to $5,000 per occurrence. Have we had testimony regarding occurrences here after January 9th?
Now, what's the testimony, Ms. Gernard?
How many different dates?
It's okay. We've got at least two. January 11th, when we served a search warrant and found alcohol inside the structure, and on February 4th, where we did an operation, purchased alcohol, and then served a search warrant and retrieved alcohol from the ownership's vehicles.
Okay, counselor, after I threatened your client with a fine of up to $5,000 per occurrence, I now have sworn testimony of 2 occurrences. So what say your client to that?
Yes, sir. I think that's what kind of lit a fire under her to come and retain counsel, and that's when I came on the case. And we've been taking affirmative steps to get them out since that point. I understand that there have been subsequent violations, but I don't think it necessarily makes the city whole to penalize her when she's taking the affirmative steps to remove them from the building. I don't know if Ms. Tran wants to say anything further about it.
Yes. Mr. Magistrate, I always want to make this building better. And I don't know about the past of their, what happened in the past that they selling alcohol without permit. And start in December when I got from Mr. Mark Jones that he sent me a letter, a notify that they have alcohol without permit, and all that takes step to the hearing on January 9th. And because I got the rent on January, they paid the rent on January already. So that's why on the end of January, I told them that I would not accept any payment from them, and I'm going to take action, that I'm going to end this contract, and I need them to move out of there in 7-day notice, because trust me, I want to make it better. Even I'm in Texas, but I want the business, because as the owner of the property, I do want to own something and make it better, not to make it worse. So from last time that we had the hearing, I feel like it's unfair that the fine going to be on me, but I understand that in Florida, you want us to take an action. So I do take immediately the action. Trust me, the magistrate. That's all I can say. I want this to be better, not to make it worse. And I really upset with these tenants. So I don't know what to say.
What's the status of your efforts to remove these tenants?
I believe the deadline is today, Your Honor, for them to vacate, or we file the eviction action against them.
Or can I put like a lock on the door? Like, no, can't. Okay.
But we're in the process of filing it and getting them out of there to remedy this situation. And I think everyone is just, Ms. Tran is almost in the same position as the city, that she's being, adversely affected as a result of the egregious nature of these, people, whatever they're doing. They're obviously not following the rules. They have no inclination to follow the rules. But it doesn't necessarily make the city whole to penalize her when they're, as Mr. Jackson stated earlier, maybe, they're doing this knowing that it's going to adversely affect her. I think it's obvious they have no regard for themselves or their own actions.
Sergeant Blowers, City of Daytona Beach. I spoke to Tammy Tran on the phone approximately 3 months ago and warned her that continued violations, she would be subject to fines up to $15,000. So she was aware and made no effort to do anything at that time. She said she would, never followed through with it, and now we're at this point.
Okay. All right, Mr. Jackson, anything else?
No, sir, I think we presented for both cases.
All right, what is the relief the city is looking for with regard to the tenant? And what can I do with regard to the tenant? All right, with regard to both cases, I find both respondents in noncompliance. All right, now, with regard to the tenant, what is the relief the city's looking for?
The maximum fine available on the first case would be a $15,000 fine for irreparable, reversible conduct, as well as a, well, I don't even know if we want to, yeah, we'll do that. $15,000.
Wasn't the tenant here last month and represented by counsel?
He was here last month with,
So the tenant
Mr.
knows
Lambert.
what's going on?
yes.
All right, and what
And
is
he's
the
had-
relief the city's looking for with regard to the tenant?
Give me 1 second to talk something with staff.
Tell me what's authorized, that's all I need to know.
Well, what's authorized is, there's 2 points. One is that this is an irreparable, or irreversible
I find it
conduct.
egregious, I find it irreparable.
So the
I
maximum,
find
for-
the tenant was on notice of everything. I find the tenant was present when we had this very same conversation last month.
Yeah.
So I find the tenant has no excuse.
and you basically stated the criteria for determining the maximum, the amount of the fine, which is the gravity of the violation, the efforts of the tenant.
I find the
And the history.
violation has all the gravity in the world. What am I allowed to do?
The maximum is $15,000
Then
fine.
I'm fining the respondent the sum of $15,000.
That
Am I
will be on
doing
your
that
case.
once or am I doing that twice?
You're doing that once on the first case.
Which case?
Got to find the right agenda. Case number 1, SMG 022453.
All right, then with regard to case number 1, SMG 022453, I'm finding the respondent tenant the sum of $15,000.
And there is the consideration that you can continue, you can add to that fine the,
And for every future violation, the tenant will be returned to the special magistrate for consideration of a will fine, an egregious circumstance fine, and any other fine available at the special magistrate's disposal. That's with regard to case 1. What am I doing with regard to the tenant as to case 2?
as the case 2, we will leave that as a repeat violation, which will fine, based upon your rulings in the last proceeding, and we're asking for the 2 occurrences, and the maximum is $5,000 per occurrence.
So you're looking for $5,000 for 2 occurrences
Right,
that I have to impose now.
yes.
All right, with regard to case number 2, SMG 022452, I am finding that there were at least 2 violations, and with that, I'm finding the respondent the sum of $5,000 per violation for a total fine in the amount of $10,000 as to case 2.
Okay, and I just got clarification from our inspector, and he's correct, so I need to correct make a correction on what I said. The will fine notification was as to the property owner. As you may recall, we did not proceed on the tenant at that time because they challenged the notice. And so there was no prior finding, so this would be an issue on in the second case. And actually, based on the testimony that has been received, we can proceed as a irreparable reversible. They wouldn't put on notice that they were subject to a fine by their notice of hearing, and that fine could be up to $15,000. So since we can't really treat this like a will fine, and I'll tell you, because of prior rulings of the local jurisdiction, I wanted to make sure that we didn't confuse an appellate court with the issue of will fine versus the irreparable, and that's why we were going to go with the will fine. However, we have the authority, the statute provides and allows for you to make a ruling that this too was irreparable and irreversible, and can impose a $15,000 fine in this circumstance as it relates specifically to the tenant. As relates to the landowner, that's the only one you actually put on actual notice and made a finding
You're
concerning.
getting ahead of me. All right, so I guess what I'm hearing is I'm now vacating the very order I just made with regard to the tenant as to case 2.
That's correct.
And instead, what I'm doing is what?
Make a
Telling-
finding
Telling
that
the
it's
tenant
rep-
to come into compliance, and that for every future violation, he'll be returned to the special magistrate for consideration of a fine of up to $5,000 per occurrence?
No, we're going to ask you to make a determination that the conduct is still irreparable and irreversible in nature, and ask you to fine them $15,000
In case two,
in case 2.
all right? I will vacate that previous order, and instead, in case two, with regard to the tenant, I do find that the harm was irreparable and irreversible, and am finding the tenant the sum of $15,000 in case number 2 as well. With regard to cases 1 and 2, I'm further ordering that for every future violation, the tenant is subject to be returned to the special magistrate for a consideration of a fine of $5,000 per occurrence. All right, I have fined the tenant twice the sum of $15,000, and in both of these cases, I've ordered a will fine for any future violations. Now, what would the city have expected the owner to do since January 9th to remedy the situation that the city thinks the owner failed to do? In other words, what could the owner have done since January 9th that she hasn't?
Give me one moment. And I do need to correct again, but
Take your
give me one
minute, and
moment.
then I'll talk for a while myself.
Mr. Vecchio, while we have a little break, maybe make an announcement for the people who are waiting on Zoom, that when they are put in a waiting room, they're not being kicked off. They're not being kicked out of, I think they're back with the IT, confused that they're being kicked out of the session, that they're just being put in a waiting room.
10-4.
Thank you.
You know how many people we have appearing by Zoom? We've only got 7 people in this audience, and if they're here for a case, that's only 7 cases, and I might just go to them directly.
Your Honor, I have 7 people in the waiting room.
Okay.
Okay, I'm back, Mr. Vecchio, and it's a couple of things.
Hang on a second. Mr. Vagovic, when did you send out your notice to your tenant to vacate?
It was last week, Your Honor. Beginning of last week.
Okay, go ahead, Counselor.
Well, while we realized your order was not until January 9th, as you've heard the testimony, this has been going on since April of 23, and at least since November of 23, it's been specifically communicated to the respondent.
I'm not impressed with the owner's efforts to date. Save your time. Fast forward
Yeah,
now to.
okay.
So,
on the
January 9th, we told her for every future violation could be $5,000 per occurrence. Now,
we would
what
like
would the city argue she has failed to do to try to ameliorate the situation as you're sitting here asking me to fine her?
Well, as from the perspective of the will fine, which I guess is what you have to look at, is the conduct egregious? It's still egregious conduct happening. Has she done everything she can do? I don't know. Right now, they've initiated paperwork. Will they follow through and complete that? I don't know. Historically, nothing's been done, and I appreciate that she has counsel on hand. Is anything filed yet? Not yet. They have the right and authority to come back for a lien review if they've diligently pursued this all the way through. But we have nothing that shows any kind of diligence for more than half a year with this owner to try and bring this under control. And as I said, the officers will testify if it wasn't clear before that they can go any day and that they're open and find these violations. This is a tenant that's sitting there waving it in the nose of other businesses as well as law enforcement and doing whatever they choose. We want the owner to do everything that's in their power to do. I hadn't sat down, we hadn't sat down to get beyond just an owner saying stop and believing that should make it stop, or an owner being able to expedite in any way their process in eviction. That's
What
something
would
I
you have
not-
expected the owner to do, having been given that warning on January 9th? Let me help you out here.
Immediately
I'd have
take
hired a
action.
freaking lawyer immediately.
Yes,
I'd
sir.
have told that lawyer, you get down there and you tell those people, knock it off, or we're removing you immediately. I'd have documented all of that. I might have even gone to the effort of hiring somebody to watch them to see if they were complying. And if they didn't do all of that, and more violations occurred, then I'd be beside myself, and I'd have found a lawyer that said, you get these people out of here now, or you at least show me something that I can take to the city and say with a straight face, I've done everything I can to try to rectify this situation, instead of sitting out in Texas and doing nothing. Isn't that about what you'd be looking for?
That's about right, Mr. LaCoucher.
That's what I thought. What say, Mr. Vagovic?
I agree, Your Honor. I think the thing is, the tenant's also wagging its finger in the face of my client, the owner. She's been adversely affected just like the city on this, and she did after, as you rightly pointed out, January 9th was the date, the operative date here. And since then, she has acted diligently, and we've done everything we can, and we are doing everything we can to remove them from the premises as soon as possible, so these violations don't occur. She has no, she doesn't gain from keeping them there. This is only hurting her, and she's undertaking all the diligent efforts she can, and we're going to remove them.
Okay. All right. You have two cases as pertains to the owner. Are you looking for relief on both of them, or are you looking for relief on one or the other of them?
Actually, that's one of the things I needed to correct. It's just taking them at the same time kind of got me giving you some confusing information. On the second case, it was only filed against the owner. It was not filed against the tenant. So on case 02-2452, the tenant was not noticed or cited. Only on the first case.
So I entered an order in case number 2 against a non-existent tenant. Okay, well, I guess I can vacate the order as to case number 2 as to the tenant. All right, so now, I'm sorry, I was asking you if one or the other of these was the city's preference, if you will, for whatever remedy it's seeking. My assumption would be, it would be case number 1, because the owner may or may not know that the tenant is opening the business after hours, especially from Texas. But she ought to know, and it would be reasonable to ask the tenant for confirmation that he at least had all the permits necessary and all the other administrative paperwork required to conduct the business he told me he was going to be conducting there. And what I'm hearing, if nothing else, is it didn't even pass muster as far as the fire department is concerned. So as far as case number 1, I have 2 violations. I'm fining the owner the sum of $500 per violation. That's a total of $1,000. That's for the 2 violations that were testified to. And I'm putting the owner on notice that if we're back here next month and I'm hearing of more violations, I had better be very, very impressed with the effort of the owner, council, and anyone else she wants to bring on board to help her fix this situation. Because absent something like that, the fine's going to go up dramatically.
Yes,
All
sir.
good? Very good. Good luck to you.
Thank you, sir.
Thank you.
That
All
was
right.
case number 2.
Pardon?
That was for case number 2.
No, that was for case number 1. Case number 1, the owner is being fined the sum of $1,000.
So we're not doing the tenant, or we are still doing the tenant on that one?
The tenant is not part of case number 2. Back up and
So-
ask me your questions. What do you want to know?
Yeah, it was case number, that one that you're talking about is case number 2, where the tenant, or where it's just the owner.
I understand that. Case number 1 is the owner and the tenant.
Right, okay.
Both of them have been fined in that case. The owner has been fined the sum of $1,000. The tenant has been fined the sum of $15,000. Case number 2, as far as the owner, for every future violation, the owner will be returned to the special magistrate for consideration of a fine of up to $5,000 per occurrence.
Now, let me,
But the only fine right now is on case number 1.
so are you continuing, because that's the status that this case was already in for case number 2, so are you just continuing the will fine? And I'm saying just.
Yes, all right, I'm continuing. I just want to make sure the will fine's in place
Okay.
as far as case 2. And, okay, now, dealt with the tenant, dealt with the owner. If there's any other relief the city's looking for, I assume I can't order you to padlock the door.
No, that would be
That'd be
beyond
cool.
your authority, but hopefully that these orders will be something that can aid in
Okay.
accelerating the
Ms. Tran, Mr. Vagovic, good luck.
eviction.
You got your hands full. You got your hands full. You got a slow burn going on down here in the city of Daytona Beach. I think you can see that for yourself. Like I said, we're not here to crucify you, but if we find ourselves in this same situation next month, you'd better overwhelm me with the owner's efforts to rectify the situation.
And I know
Yes,
we're
sir.
closing, but also pointed out something that would just be beneficial, and whether you order it or not, I think it would still be beneficial, and that's that this owner, since she is an out-of-town owner, obtain someone to manage this property and ensure that they're not violating the law.
Well, I'd love to be tell the owner to do all kinds of things, but that's one I don't think I have the authority to do.
You could order to obtain the property manager, although I guess she has a
Well,
tenant, so
I
you're
could make
kind
all
of a
kinds of
third party.
suggestions to the owner, but I don't think that's something I can order them to do. All right, good luck,
Thank you.
folks.
Can I ask you one question? Sorry, I'm not clear with the 1,000 fine. On case 1, the after hour that the tenant opened, what is the fine of 1,000? What is the fine of the 500? You said 2 violation.
$500 per occurrence for the 2 instances in which the officer testified to that we clearly had violation of the business being open after hours and serving alcohol, which, if your people had a hookah license, that wouldn't be permitted. And from what I'm hearing, I don't even know that they would qualify for the hookah license, given the complaints I've heard mentioned with regard to the fire department and the condition of the building and its unsuitability even for that. So you kind of have a host of problems there.
But as the owner of the building, I still responsible for that fine on the tenant.
As the owner of the property in which these conditions are occurring, you are absolutely liable. We don't have anyway, you would absolutely be liable. Your relationship with your tenant is yours. That's not for us. We can't tell you what to do or not to do with regard to your tenant. We can only tell you what to do and what not to do. And we're telling you we're not going to tolerate these violations anymore, and we're putting the burden on you to rectify the situation.
Yes, that's why I get to Mr. Vagovic to ask his help to get these tenants removed. Because, how I put it, like, I don't like to responsible for the tenant on their violation, and I would like to take action right away. It's just that I don't know why I still get fined on these violation.
I
When
can explain it. I can explain it to her later on, so we don't waste time at the hearing. They have a lot of
Your,
stuff.
your attorney will tell you everything you need to know. That's as far as I plan on going. All right, good luck to y'all.
Thank you, sir.
Yeah, this is mine. Right.
Case number 3, Housing Authority of Daytona Beach. All right, not seeing a respondent. What say the city?
Good morning, Sarah Kirk, Inspector with the city. My credentials are on file. This was a complaint-generated case that I received on July 12th of 2023 for unsanitary interior services, faulty electrical lighting, and defective plumbing. First notification was November 7th of 23. I haven't. Last site inspection was July 12th of 2023. It's a non-compliance. Staff's recommending a finding of non-compliance with compliance by the next cutoff.
Noting the absence of the respondent, after hearing the testimony of our inspector and viewing the photographs presented in evidence, I find the respondent in non-compliance. And when did you want the respondent in compliance by?
Next cutoff, please.
In order the respondent to come into compliance by March 6, 2024, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Case number 4, Track 3 LLC. Anyone here for the respondent? Yes, sir. If you would please state your name and be sworn.
State your name. I'm sorry, can you speak in the mic? I can't hear you.
My name is Morid, M-O-U-R-I-D, last name Adib, A-D-I-B.
A-D-I-B.
Yeah, as a boy.
Raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes, I do.
Thank you.
Yes, sir. What is your affiliation with Track 3 LLC? Are you the owner, the manager?
I'm rent the building.
Pardon?
I'm rent the building. I'm rent.
Tenant.
Okay. Do you have authority to speak here on behalf of Track 3 LLC?
Yes, sir.
Okay. All right. Let's hear from our inspector.
Good morning, Mr. Vakilja. For the record, my name is Steve Alderman. Credentials are on file.
You know what? Hang on one second. Do you agree these violations existed or occurred as stated in the notice of violation?
Yes, sir.
All right. I find the respondent in non-compliance. All right. What do you want the respondent to do, and how much time should be reasonably required?
I'm sorry. This a finding of non-compliance with next compliance due next cutoff, and all he needs to do is fix the damaged awning.
All right. The all right, I find the respondent in non-compliance. The city seems to think you ought to be able to have this taken care of by March 6th. What say you to that?
I got the company. I hired the company, and they have the money down, and they told me give me about between 4 to 6 weeks finish that.
It would be what now?
4 to 6 weeks to finish that stuff. The company today.
So if I gave you till April 3rd, it would be done?
Yes.
Promise?
Maybe before that.
Maybe before that.
Yeah.
All right. All right. And I assume we're going to be doing all the necessary corrective electrical work that's mentioned here as well?
The electrical is done.
Pardon?
That is all done.
That's all done.
That's all
Everything done.
Very good. Okay, very good. All right, I will allow I'll give the respondent until April 3, 2024 to come into compliance or be returned to the special magistrate for consideration of fine of up to $1,000 per day thereafter. Good luck to you.
Thank you, sir.
You're welcome. Case number 5, 1215 North Atlantic DB LLC. Anyone here for the respondent? Yes, ma'am. If you would please state your name and be sworn.
Lauren Beauchamp,
Sorry, spell your name.
Beauchamp.
MP. Your first name?
Lauren.
Lauren. Raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth? Thank you.
Yes, ma'am. What is your affiliation with 1215 North Atlantic DB LLC?
I work with that management company. Just took over the property.
You have authority to speak on their behalf? Do you agree this violation existed or occurred as stated in the notice of violation?
My understanding, they were violated or a fine was put in. They did hire someone to fix it. He came, he put 2 boards up, said the city came, told him they needed an engineer. The guy disappeared. Since then, they fired the management company. They want to fix it. They just need to know what avenues to take, what's required.
All right, well, why don't we back up and start with our inspector. Mr. Inspector.
Yes, sir. This is a complaint-driven case for violations of a permit required for a deteriorated overhang, damaged fencing, trash debris, overgrown landscape, exposed electrical lighting. Everything is done except for the deteriorated overhang and the completion of obtaining a permit.
What property is this?
Right across from the new construction on A1A at 1215 North Atlantic.
Got a sign up that says Atlantic Breeze. That was the
Okay, so it's a motel on the west side of A1A. Gotcha. And that's the noncompliance right there?
Correct.
All right, well, based upon our inspector's testimony and the photographs presented, I find the respondent in noncompliance. Is that what has to be fixed to come into compliance?
Correct.
All right, and are you looking for compliance by the next cutoff?
Yes.
All right, the inspector seems to think that the respondent ought to be able to take care of this by March 6, 2024. What say you to that?
Can I use your pen?
Pardon?
Can I use that pen? Yeah, I think that should be okay. We just have to pull a permit, right?
You have to pull a permit. You probably need a contractor or an awning company or a sign company. I don't know what exactly that is. And then you have to have all that done by March 6th of 2024. You're going to have all that done.
Make sure.
Okay. All right. If I didn't say it already, I find the respondent in noncompliance and order the respondent to come into compliance by March 6, 2024, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Good luck to you. If things don't go according to Hoyle and you find out you're running out of time, you get that man's card and you keep him posted as far as everything you're doing. Because then if perhaps you blow by March 6th without being in compliance, if you've kept him posted as to all your efforts, then that will make a big difference. Good luck to you. Case number 6, Hodgdon International College Incorporated. Is there anyone here for the respondent?
That's a Zoom case, Your Honor. One moment.
All right, I had a feeling it might be. And we have a person here. Where did our guy go? What's that?
IT, are we pulling up someone? Yes. Okay, thank you.
Did somebody think that was
That's
helpful?
their video feed. I don't know if they have their camera blocked or not sure.
Who are you, sir?
I'm the general contractor that they hired to take care of the property.
They're unmuted, so
I'm unmuted. Okay. Do we have anyone on Zoom?
Yes, good morning.
If you would, please state your name, and you and your contractor need to be sworn by our secretary.
She needs to turn on her video.
We're not unable to swear someone that we are unable to see.
Sorry about that. We can't see you, ma'am.
Yes, give me 1 second.
Asking if they can hear you.
Can you hear me?
I can hear you, but we have to be able to see you.
Yes. Hold on, give me 1 second, please.
Don't know. It's not showing. Oh, do it on your phone. It might be better on your phone. Just tell them that you're trying to log in from a different device.
Trying to. I cannot.
All right, folks, just listen in. We're moving on. Okay.
Okay.
Yes, sir. If you would, please state your name and be sworn by our secretary.
State your name.
Todd Brussells.
Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth? Thank you.
All right, did I understand you to say you're the respondent's contractor?
That is correct.
So I assume you'd have authority to speak on their behalf?
I haven't specifically asked them that question, but I will assume yes.
All right. Would you agree these violations existed or occurred as stated in the notice of violation?
I'm not sure I understand the violation. Could that be made clear to me?
All right, then let's go with our inspector instead. Mr. Inspector.
Inspector Jean-Baptiste, certified inspector. This is for 228 North Ridgewood Avenue. Field observation on August 3rd, 2023 with the following violation. Failure to clean damaged exterior walls, remove graffiti, dirt and grime, damaged soffit and fascia board, trash and debris on the property, failure to repaint, exposed wires, and unmaintained landscaping. Notice of violation was sent and generated. Property was posted on August 18th, 2023, the compliance date of September 18th, 2023. A re-inspection on December 19th found the facility not to be in compliance. This is a vacant commercial building that is on Ridgewood Avenue. I have met with ownership and contractor. The work is progressing right now in regards to asbestos that they found on the property. At this time, staff is recommending finding of non-compliance to be in compliance by the next cutoff. However, there may be some extenuating circumstances based on permitting and everything with the asbestos. So I'll allow him to speak on that.
Okay, does your recollection pretty much comport with what he had to say?
Yes.
All right, I find the respondent in noncompliance. The inspector is wondering if you may or suggesting you may or may not be done by March 6, 2024. And I'm not trying to put words in his mouth, that's me talking.
Right.
What say you to that?
The soffit probably wouldn't be able to be repaired that quickly because that's going to be part of the overall project. So we're pulling a permit to renovate the building inside out. I haven't submitted that permit application yet. What I have submitted is the permit application to do structural repairs on the south wall because I do have the plans for that. The only reason I haven't submitted the permit for the entire project is because I do not have the blueprints ready. The mechanical, electrical, plumbing people should be done with their section by the end of the week. And then all we have left to do is the parking lot plan. And I would be able to submit for the overall permit for the building. But as far as that soffit getting fixed, that's probably not going to happen for at least a couple of months, just based on what needs to happen first, second, third in the project.
You satisfied with the effort so far?
Satisfied, yes. They're in the process of getting everything done. So as such, we're willing to follow through until everything is done properly, if they have obtained all the proper permits. At this point, they're well in the way of getting there. So we could come back, per your discretion, of course, for a progress report if that needs to be.
All right. So how close do you think you're going to come to being done by April 3rd?
Done with what? The entire building?
I'm trying to avoid interim stuff here if I can.
April 3rd.
So when do you think you're going to be done with the whole project? Well, I don't even know that being.
I would say June. We should be completed by June.
All right, does that mean the landscaping, the exterior walls, the graffiti, the dirt and grime, the damaged soffit and fascia, the trash, debris, the repainting, and the electrical wires will be worked on all the way up till June?
That is correct.
All right, then I will have you all back on our April 9th, 2024 meeting for a progress report to see where we stand, and at that point, hope to establish a compliance date.
Okay.
Okay, very good. Good luck to you.
Thank you.
Thank you.
Thank you.
You're welcome.
Yes, thank
I'm sorry.
Case number 7, Daytona Ridgewood LLC.
Mr. Vecchio, quick question. You did find them in noncompliance?
If I didn't, I find them in noncompliance now. Case number 7, Daytona Ridgewood LLC. Good morning.
Good morning, Your Honor. My name's Christia Hoffman, and I represent Daytona Ridgewood.
You said Christina?
I have
Christia,
someone via Zoom here.
K-R-I-S-E-I-A. Hoffman.
Okay, do we have someone appearing by Zoom?
Yes, good morning. Ashley Rose on behalf of the landowner.
Okay, are you an attorney?
I am. I'm general counsel for the landowner entity.
Then we don't need to take your oath. All right, all that having been said, Counselor, do you agree these violations existed or occurred as stated in the notice of violation?
Yes, Your Honor, we don't dispute.
All right, then I find the respondent in noncompliance. Mr. Inspector, how much time should reasonably be required for the respondent to come into compliance?
The next cutoff, please.
City is suggesting you ought to be able to have this work done by March 6th. What say you to that?
Your Honor, we're requesting 90 days to reach full compliance. There are several violations, and we need to take the steps to pull permits and hire contractors. The legal team is on it now. There have been 2 work orders submitted. The landscaping issue has been resolved. We're waiting on a quote for the parking lot repairs. But yeah, just pulling those permits and hiring the contractors to actually get the work done, we foresee taking 90 days.
Okay, what say the city to the respondent's request for 90 days?
Mr. McKellar, it's worth noting that this violation was observed on July 25th, 2023, and the property was posted on August 3rd, 2023, at which point, gentleman from management staff, I would assume, says that they were not going to do anything until I submitted the notice of violation, which we did. They further said that we've never gotten anywhere with the folks that were there. And as you see, this is the Family Dollar that's right there on Ridgewood. So per my interaction with management there, I do not have any faith that anything will be done within 90 days because nothing has been done since August 3rd, 2023.
Wow, that doesn't sound good.
Yes, Your Honor, we are aware that the case has been floating around and has not been moving up to this point, but I assure you that legal team is on it now. Like I said, we have submitted those 2 work orders, so we are getting some things moving, and going to take care of it in the next 90 days.
Miss Hoffman, could I ask that you submit your contact information to me as well? I've been reaching out to the tenant contacts for several weeks with no avail.
Absolutely, I can. I have not been on this case very long myself.
Well, doesn't sound like we have a very good history here so far, so here's what we're going to do since you've asked for extended time. I'm going to have you all back at our March 12, 2024 meeting for a progress report. And if I'm impressed by the progress, then maybe I'll consider the amount of time you've requested. If I'm not impressed by the progress, then I won't. All right, so on March 12, 2024, I'll have the respondent back for a progress report, and then we will then revisit the compliance date.
Okay, thank you, Your Honor.
Okay, good luck to you.
Thank you.
Case number 8, Cerberus Investments LLC. Anyone here for the respondent? I assume you on the other side of that panel will let me know if we have any Zoom people appearing.
Yes, sir.
You can bang on the wood just to remind me you're there every once in a while.
No problem. Thank you.
Okay, case number 8, Cerberus Investments LLC. Not seeing a respondent, what say the city?
Inspector Bostwick with the city, credentials on file. This case was field generated, opened on November 16th of 2023, overgrown vacant lot, trash and debris. First notification was on November 29th of 2023. Property was posted. Compliance was due by December 11th of 2023. Last day of reinspection was February 9th of 2024. Result, non-compliance with no contact from the owner. Staff requests a finding of non-compliance with compliance due next cutoff.
All right, noting the absence of the respondent based upon the testimony of our inspector and the photographs put into evidence, I'm finding the respondent in non-compliance and order the respondent come into compliance by March 6, 2024, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Case number 9. Jonah Bolu.
Morning, my name's Jonah Blue.
Yes, sir.
Sir.
If you would please be sworn by our secretary.
Raise your right hand. You swear or affirm the testimony you're about to provide the truth, the whole truth, nothing but the truth?
I swear.
Thank you.
Okay, Mr. Bolu, do you agree this violation existed or occurred as stated in the notice of violation?
Yes, it did.
Find the respondent in non-compliance. Mr. Inspector, how much time should reasonably be required for the respondent to come into compliance?
Next cutoff.
City seems to think you ought to be able to be in compliance by March 6th. What say you to that?
Can I speak?
Yes.
Okay, this was a tool shed temporarily while I'm building a new construction home that I plan on storing my personal belongings, tools, and I even sleep there sometimes. So it's kind of like a...
Sleep in the tool shed?
Yes, I do, sir. It's my house.
The tool shed's your house?
Temporarily, yes, sir.
This is sounding all right to you?
Well, I'm not really a rich person, so it's fantastic for me.
All right, I shouldn't have interrupted.
I do have a permit that I filed with the city. I can give you the permit number. It's right now under review. And it's been under review for the last 2 months or a month or so now, and I'm not sure exactly why they're not. And I'm also building a new construction home, which the permit is applied with the building department. So I could give you those permit numbers right now.
Okay, right now, what I need to know is when you're going to remedy the unpermitted structure on a vacant lot, and I guess remove tree debris. Is that what it is? Remove tree debris?
Yes, sir.
Well, I applied for the permit.
Okay.
And it says under review. And then the reason they're stalling me with the permit, I don't know why they didn't deny it or whatnot, was they said there's no structure on the property, so I can't have an accessory structure until there's actually a real structure.
Right.
Which I have my structural, speaking of structure, I have my structural engineering plans that I submitted to the building department, which are also under review. So in the meantime, I would like to keep this shed on the property while I'm building a new house, and I plan to remove it once the house is done.
Okay, well, I don't have the authority to allow you to do that. I don't know who does. All I know is I don't.
Okay.
So it's not as though I can just waive the
I'm not asking
the
you to do
ordinances,
that.
the code and the ordinances. So if it's an unpermitted structure on a vacant lot and it's prohibited, then it's prohibited. I can't say it's not prohibited. It either is or it isn't. Sounds as though it's unpermitted. And now the question is, when is it going to be removed? Now, if you have some administrative remedy available to you that might allow you to keep that there, then I'll allow you to pursue that.
I mean, it is.
But I don't know what that is.
property. I did apply for a permit.
I heard you.
Yes. Okay, that is where I live.
Okay, well, that part I'm not understanding, but.
I'm not a rich
anyway.
person, I'm sorry.
I heard that part too.
Okay.
Okay. Now, Are you going to have this rectified by March 6, 2024, or do you have an alternative time you want to propose?
The rectification would be,
I'm assuming either get a permit for the structure or remove it. Isn't that what it would be?
Correct.
And
Well, yes.
rectifying the tree debris.
I'm working on the trees right now. I got a quote from a landscaping company. They wanted $12,000 to clear the lot. So I decided I'm going to do it myself. And I'm getting progress done.
All right. Well, I'll give you until March 6, 2024 to come into compliance or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter.
Okay.
I don't think you're going to be allowed to do a lot of what you're looking for, and that's not my business. That's yours. But my point is, if you think there's some administrative remedy available to you out there that might afford you some relaxation of what appears to me, you either get a permit or you remove it, by all means, you have every right to pursue that. That's as much as I need to say in that regard. Good luck to you.
Okay. So the remedy was either remove it or get the permit?
Yes,
Okay. By March 6th.
by March 6th.
Understood.
You know, and if you have, anyway, and by all means, it never hurts to keep the inspector posted as to what's going on and what's happening.
Okay. Well, if I don't get the permit, I have to remove it, so. Understood.
Yes, sir.
We have been in contact before. He has my number.
Yes.
Okay.
Yeah.
Good luck to you.
We're working on it.
All right, good luck.
Okay, thanks.
Case number 10, Felicia Ray Dura. Anyone here for the respondent? What say the city?
This case was field generated, opened on December 20th of 2023. Overgrown vacant lot, trash and debris, recreational vehicle, and cars parked on a vacant lot. First notification was on January 5th of 24. Property was posted. Compliance was due by January 16th. Last day of reinspection was this morning. The lot has been cut. The vehicle has been...
I'm sorry, what now?
The lot was cut.
Okay.
And that vehicle was removed. However, the RV is still there. I spoke with the owner for the first time on February 9th. Staff requests a finding of noncompliance with compliance due next cutoff.
Okay, noting the absence of the respondent based upon our inspector's testimony and the photographs put in evidence, I find the respondent in noncompliance and order the respondent to come into compliance by March 6, 2024, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. We did case number 11 is in compliance. Case number 12, Ernest Deloach Jr. and Dolores Riles. Anyone here for the respondent? Not seeing a respondent, what say the city?
This case was field generated, opened on October 17th of 2023, overgrown vacant lot with trash and debris. First notification was on October 24th. The property was posted. Compliance was due by November 4th of 2023. The last day of reinspection was February 9th of 2024. Result, non-compliance. I've been in contact with the owner. Staff requests a finding of non-compliance with compliance due next cutoff.
Noting the absence of the respondent based upon our inspector's testimony and the photographs presented into evidence, I find the respondent in noncompliance and order the respondent to come into compliance by March 6, 2024, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Case number 13, U21 Holdings, LLC. Is there anyone here for the respondent? Not seeing a respondent, what say the city?
This case was field generated, opened on November 2nd of 2023, overgrown vacant lot with trash and debris. First notification was on November 3rd. Property was posted. Compliance was due by November 13th of 2023. The last day of reinspection was February 9th of 2024. I've been in contact with the owner. Staff requests a finding of non-compliance with compliance due next cutoff.
Noting the absence of the respondent based upon our inspector's testimony and the photographs presented in evidence, I find the respondent in non-compliance and order the respondent to come into compliance by March 6, 2024, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Case number 14, Adams Investment Group, LLC. Anyone here for the respondent? Not seeing a respondent, what say the city?
Inspector Garcia, credentials on file with the city. The respondent was first notified of all the violations back in September 27, 2023. Since the last hearing, I've had no contact. The property is occupied, and this case is a rental. It's due for a rental inspection. It's actually, that's the only issue that we have. The rental inspection is due today at 1 o'clock, so we're asking to amend to the next cutoff, allowing them to get that rental inspection done, and we'll know if it passed or not. So amending the next cutoff.
Noting the absence of the respondent based upon our inspector's testimony, I will amend our current order of noncompliance to allow the respondent till March 6, 2024 to come into compliance or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Case number 15, Pelican Bay Golf Club, LLC. Anyone here for the respondent? Not seeing a respondent, what say the city?
Yes, sir, Officer Clegg, my credentials are on file. Respondent was first notified on September 27th of 2023. The case is, all the violations are in compliance except for this last one, the driveway. Samsula Demolition has a contract, they've been paid to fix this, but they're going to be another 2 weeks out. They're doing a multi-million-dollar contract, so city's requesting to amend the next cutoff.
Noting the absence of the respondent based upon our inspector's testimony, I will amend our current amended order of noncompliance to allow the respondent until March 6, 2024 to come into compliance or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Case number 16, Mark A. and Julie L. Walshager.
Good morning, Corey Brown with Storch Law Firm, 420 South Middle Road, Daytona Beach, representing the Walshlagers.
All right, this matter is here for the imposition of a fine, so let's hear from our inspector.
They were first notified of this issue February 24th, 2022. Since the last hearing, I've had progress and contact with the owner. The work is ongoing. Unfortunately, they've had a few less working days than they would have liked. I would like to amend to the April cutoff to allow the work to be complete.
You say they've been at this since February of 22?
That's when the case started. The work started a few months ago. The actual permitted work started a couple months, or 4 months ago now, I believe.
Okay.
But since then, they have been moving forward at a reasonable pace.
Okay. I'm sorry, I was just mystified by this structure I'm looking at here.
Yeah, it's
I can't quite
actually
figure out what it is.
mostly done. That's a form so they can pour on top of it, I assume. Yeah, so that's actually just the capstone. The actual wall is in place. So they're just pouring a cap's basically what's left.
All right, I'm sorry. So you were proposing to amend it to when now?
The April cutoff?
What say you to that?
Sounds good to me.
Very good. Okay, I guess in accordance with the agreement of the parties, I will amend our current order of noncompliance to allow the respondent until April 3, 2024 to come into compliance or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Good luck to you. Case number 17, Lauren and Herb Kawesh. Anyone here for the respondent? Yes, sir. If you would please state your name and be sworn. Hello?
It's Herbert Cowish.
Raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes, ma'am.
Thank you.
All right, this matter is here for the imposition of a fine, so let's hear from our inspector.
All right, they were first notified of these issues on May 23rd, 2022. Since the last hearing, I have had contact and progress, and they do continue to move forward with the project. I would like to amend to the April cutoff with the understanding that the steps will have the final permit done by that point.
What say Mr. Kawesh to that?
Sounds good to me. Yes, sir.
Okay, now, I understand an April 3, 2024 cutoff. What were you trying to tell me with regard to these steps?
The steps need to be finalized by that point. I've decided to give them extra time due to some personal issues of the contractor that were no fault of the owner, but with the understanding, because the progress hasn't been quite what we're looking for, that they would need to finish that in this 2-month time frame.
You understand that, Mr. Kawesh?
Right, and then there are other issues being worked on, and permits have been opened, and we're just waiting for things to, finish up on those as well at a later date.
Steps included.
No, the steps will be completed by April, sir.
All right, I just mentioned them because the inspector did. All right, I will amend our current order of noncompliance to allow the respondent till April 3, 2024 to come into compliance or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Good luck to you.
Thank you, sir.
You're welcome. Case number 18, Sunshine Ventures and Management, LLC.
Good morning, Your Honor.
Good morning. All right, this matter is here for the imposition of a fine. What say the city?
I'm sorry, can we?
Oh, I'm sorry.
State your
I
name?
apologize.
Kobe Betzalel.
I'm sorry, spell it for me?
Koby. And last name Betzalel. It's B as a boy, E-E-C-A-L-E-L.
Okay, thank you. Raise your hand. Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
I do.
Thank you. You can pull the mic up. So
All right, this matter is here for the imposition of a fine. What say the city?
Good morning, John Stinson, Code Inspector with the city. My qualifications are on file. This respondent was first notified of violations on 16 June of 2023. Since the last hearing, I have been in contact with the owner, the contractor, and the citizens in the immediate area. The property is currently being maintained. However, they just obtained approval for their rezoning on 2/9. They have not applied or have been issued any permits to do any work. No work has begun on the property.
And work.
Please hold on. Just a little correction on that last one. The 2/9 date, yes, the 2/9 date is when the information was entered by the building department. Nothing has occurred as far as permits being applied for or issued for this property. The only thing that has transpired is the approval. The city is asking for the imposition of a fine of $200 per day to be capped at $25,000.
Okay, what was the approval you just told me they got?
Rezoning. The property had to be rezoned.
Rezoned for what purpose?
For the purpose of renovating the motel back to its glory days and even better.
To renovate it back to what now?
To renovate the motel.
Had it been a hotel historically?
It was a motel before, and we are the new owners of that property.
And the property had to be rezoned to operate it as a
That's what we
motel
understood.
again?
That, I mean,
Huh?
that's what we understood, that there was supposed to be a approval for rezoning the property and also get extension for the plans, or no, not for the plans, for the and so far, again, we corrected everything that we've been asked for as far as the boards. We cleaned the property from any construction debris from previous owners. We replaced the gate. We fenced the pool and covered it. We take care of the lawn and, with regular vegetation, cleaned and trimmed. And
When do you expect to be in compliance?
so we are working with architect and engineering company under the name of Amphion Engineering. And we are working with them to get all the plans to the current code. And we're really close to getting the permit submitted.
Okay, can somebody explain to me why I have orders telling the respondent to come into compliance within 30 days, going all the way back to September of 2023? I got a September 2023 order. I've got an October corrected order. I've got a December order imposing fine. I previously fined Sunshine Ventures $3,500.
Correct, and we pay that.
Ms. Vickels, you may recall, I believe it may have been in, and we have citizens that are here today, but I think the citizens came forth, I think it was November, perhaps, of last year. And, yeah, the citizens came forth. There had been, as best I recall, maybe even a change of hands in ownership, but there was a expectation that there would be development on this property. This is that former Indonesian hotel there at the corner of.
Or what now?
Indonesian hotel. Also, some people has the name Jesus Motel. I don't know where that came from, but it's the property right at the corner of University and A1A. And you've been
Did
provided.
you just buy this property?
Yes.
We had another guy in here on this just a couple months ago.
That's correct. Back, we had someone else previously that was there. I don't know if it's on behalf of the owner or.
On our behalf, Mr. Greg Kong.
And you made it real clear that they need to get going on this project if they're doing a project. You've been provided, I believe, a correspondence from Mr. Morris, who is the deputy city manager and manager of growth management and planning. And I believe you have a copy of that, and that basically expresses that the things they needed to do was they had to renew the PD application, and they had moved forward that and got, they were formally approved site plan. They had to get that renewed as well. And they had to get city staff to reapprove. And those things have happened, but they happened now a little bit ago, and where we are today is that they've done nothing afterwards. I believe that happened in December, is what staff is noting, and even since then, as noted by the Mr. Morris, given the status of the case, the aggravated nature of the property to the surrounding neighborhood, restoration of the property needs to be moving along, and it just hasn't been. There's, they haven't received any, the city has received, they hadn't filed building permits, is what I'm seeing, as of February 12th, 2024. So they hadn't filed permits. They aren't moving forward, even though they have the approvals to do so. So that's the status. They were fined because of the necessity to properly handle life safety issues that were on the property, mainly covering a pool and fencing and so forth. But it sits since December as it's today, just as it has been. And so
That's not entirely correct. I mean, it's not like we haven't done anything. The DP was extended. We got
Don't waste my time with the history lesson.
No,
I've got a
but we keep
photograph showing
maintaining.
the current condition.
We keep maintaining, we repainted the boards. We've done everything that we've been asked for. And again, the only thing that
Okay,
is
now, the
based,
property's an eyesore and it needs to be fixed. I want to hear when it's going to be fixed.
so as I mentioned, we are working with the architect and engineering
Not good enough.
to submit
Give me
that.
dates when things are going to happen.
We hope that by 90 days, we'll have the permit submitted.
90 days, you'll have what?
The permit submitted,
The permit submitted.
yes. So we can start doing the work, yeah.
How long are you with Sunshine Ventures in management?
Yes, sir,
How long have you been affiliated with them?
always,
Always?
yeah.
And how long have they had this property?
With they,
Sunshine Ventures.
since the middle of last year,
So you've had this property since June of last year?
yes,
And that's what it looks like today?
we believe it's been since March, which would be almost a year.
correct. And again, we kept maintaining it and did everything that we've been asked for as far as taking care of the boards, reboarded the windows, painting them, cleaning outside, taking care of the lawn and vegetation and whatever, the pool cover. So all that we took care for. By the time that we're still working with the engineering and architect to get the plans done and submit the,
So do you have plans for this?
yes, we are working on them. Yes, sir.
No, no. Do you have plans?
Yes, I mean,
Done.
they were not submitted yet, but we are working on the plans as we speak. Yes.
So you don't have your plans done yet?
Not, they are not done yet.
And you haven't applied for a permit yet?
Not yet.
I do have two citizens that would like to be heard.
I don't need to hear from the citizens. I know enough about this property. Are you offended if I don't talk to you? Yeah. All right, well, be offended.
May I add something else, sir? With the same group of investors that holding this property, so we have other properties that we truly care for, like the Streamline Hotel, that since we are the owners, I know that there was issues before, but since we are the owners, there's no issues. We also own what used to be the Camellia Motel, now it's Oceano Suites. We took care of it from a dilapidated property to a really nice and boutique motel.
What do you have in mind for this property?
Even make it even better than Oceano Suites. It's going to be like really a boutique style hotel.
So you got something to show me?
I can show you pictures how the Oceano Suites looks like.
No, I'm talking about this property.
So yes, again, we are working on the plans.
That I drive by
I know.
every,
Believe me, I want that as well.
at least 2 to 4 times.
I know, and we want that as well, and we're pushing for it as much as we
And
can.
it has been a flop house at best.
I know, but it's not.
Historically.
I know, but it's not easy, but we're definitely on the way there. We are really close to getting the permit submitted.
Okay, Mr. Inspector, what is the next thing you would like to see in this timeline I'm being told about that's going to convince me that something's actually happening?
The city would like to see permits applied for and issued.
Permits applied for and issued.
That's correct.
Have you applied for permits yet?
No, not yet, but we're working on that.
All right, I will hear from one of you. Come on up, let's talk. State your
Hi.
name, please, and be sworn.
Emily Nice. I'm the Seabreeze Neighborhood Watch chairperson.
You have to be sworn.
Raise your hand. Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes.
Thank you.
Thank you. So, you know, we've been dealing with this for quite some time. The remaining issues have been reported to me and lots of other neighbors, of course. The adjacent properties have children in them, and those parents have told me that there are rats in and out of the building constantly. There are still 6 openings of the boarded window areas. You can see an opening right there at the top. That's probably 15 feet from the next building where children live. And they're disgusted by the rodent activity that they see. So this is such a simple repair. I would think that if someone was genuinely concerned about the welfare of the area, that a handyman could go in and properly set a board in a window. There's another opening right there up top, 6 total. At least put the boards up in the openings and do your neighbors a favor so that we don't have to watch the rats go in and out. That's a public health hazard. So I just wanted to share, we all still remain concerned and appreciate anything you could do. Thank you.
What are the plans for this property?
Again, it's going to be a boutique hotel. That's exactly it.
Okay, what are you going to show me over the course of the next 30 days that's going to persuade me that you're actually doing something noteworthy here?
I can show you the progress that we have with the engineering and making the plans done. But again, we're working on that.
Okay, Mr. Inspector, I understand permits being applied for, permits being obtained. You expect permits to be obtained on a renovation like this? I mean, I don't know, I'm asking.
I believe so, sir.
Within 30 days?
I believe so, sir. They have had more than enough time to put together their application on their designs. They've had plenty of time to submit and have those their submission reviewed and approved. So there has been plenty of time to get that done. Nothing else has changed since the last. None of the requirements have changed, so they should not have to go through a whole lot of changes to obtain these permits.
And if I could add this, tell the representation of Mr. Liddell. They've had experience, they know how and what's necessary, and tremendous experience indicates in procuring and improving properties here.
Was he lying?
No, I'm saying in light of
I'm
that,
asking. He says he worked on the streamline. Isn't that what you said?
Yeah.
Is the streamline nice? I don't know. I don't hang out the streamline.
I couldn't tell you. Neither
Okay,
do
well,
I.
a man saying he's made these local projects, showpieces, I was wondering if that was true or not.
And Streamline is an active business in the city. That's all I can tell you.
And all I'm saying is, with that representation, he should be able to make it through this process relatively smooth.
Okay. I'm going to schedule this for a progress report at next month's meeting. In the interim, the property is going to be secured to city standards, and that includes getting an exterminator in there
Will do.
within 10 days of today's date. Failing that, you will be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. You tell me you're going to turn this into a showpiece. You convince me you're going to turn it into a showpiece, then I would be inclined to work with you in the hopes that we would have something nice and permanent for everyone in the area, myself included. I'm probably not supposed to admit that self-interest, but whatever. But in any event. But in the meantime, it's going to be secure. We've already taken care of the pool. I'm not hearing any complaints about the pool, but I want the property secured to city standards. There will be no openings. The inspector will be by to satisfy himself that it does meet city standards. I want that fence maintained. I want that pool maintained, and I want you to get an exterminator in there. And then next month, with all due respect, I don't want to hear adverbs and adjectives like progress and beautiful and this, that, and what have you. I want to hear dates and times as to what we can expect. Because if I come to the point where I think I'm just being BS'd here, then the time is up. Because we've all looked at this for too long as it is already. Okay? If I'm satisfied that you're making a genuine effort to turn this into something, that's another matter. So, we will have a progress report at our next meeting. You will take care of those items within the next 10 days. If you have any question as to what it means to secure it to city standards, if you ask our inspector, he'll let you know. And then, like I said, you're going to get the exterminator in there as well. And when I say I want it secured to city standards, that doesn't mean whatever hole I happen to be looking at right now. That means the fence. That means the pool. That means everything. That means it's maintained. No rubbish, no trash, landscaping's maintained, the whole 9 yards. So, get the neighborhood off your back as far as those fundamentals. Impress us with what you have planned for it, then we'll talk. Fair enough?
Fair enough. Can I ask a confirmation? Can you confirm to me if the current situation is to the city standard and we'll keep on keeping that for the time being?
He can meet you on site.
Well, I'm sure he'll have
What?
to inspect
He'll meet you
it.
on site.
Okay, because
I
if,
can tell you right now, if there's openings, it's not.
okay, all right.
Okay. All right. Folks, you're welcome to come on down whenever you want. You know, slowly but surely going to push the rock up the mountain. Good luck to you. And good luck to you.
Thank you, sir.
I'm looking forward to seeing what you do here.
Will do. Thank you.
Case number 19, GEA Seaside Investments Incorporated. Anyone here for the respondent? Not seeing a respondent, what say the city?
Alrighty. The respondent in this case was first notified on October 24th of 23. Since then, there has been no contact, no progress, no change in the property status. The city is asking for the imposition of a fine, one-time fine, for the lack of a rental license is $250. And for the parking violations, I am asking for $200 per day to be capped at 15.
All right, noting the absence of the respondent based upon our inspector's testimony and the photographs put into evidence, I am ordering the respondent by March 6, 2024, to pay the $250 rental license fee. I think that's how I do those. And I am fining the respondent the sum of $200 per day, commencing February 8, 2024, and that fine will continue to accrue each day thereafter until the property is in compliance or the amount of the fine has reached the sum of $15,000. Does that take care of that one?
Yes, sir.
Case 20, Bruce Beardsley. Anyone here for the respondent? Not seeing a respondent, what say the city?
Oh, I'm sorry, the property is in compliance as of yesterday. Yesterday is the February 12, 24. Compliance date.
Case number 21, Adiba Shuja. Anyone here for the respondent? Not seeing a respondent, what say the city?
This respondent for this case was notified on August 25th of 2023. There has been no contact with this property owner. There has been changes in the property. I have issued a stop work order for work without permits. Currently, in this particular case, nothing else has been achieved. The city is asking for $200 a day to be kept at $15,000.
Noting the absence of the respondent based upon our inspector's testimony as well as the photographs presented, I'm finding the respondent the sum of $200 per day commencing February 8, 2024. That fine will continue to accrue each day thereafter until the property is in compliance or the amount of the fine has reached the sum of $15,000. Where is 530 Cannon Street?
It's right off of North Street. If you would take Washington from Mason south, it would, when you get to North Street, you'd make a quick right, quick left.
Good enough. Case number 22, Victory Temple of God Incorporated. Is there anyone here for the respondent?
This respondent was here, he is, but they're no longer in.
And state your name.
R.T. Hillary?
Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes, sir.
Thank you.
All right, we're here for a progress report. And I see a note that says the property was to be secured to city standards and maintained. Has the property been secured to city standards, Mr. Inspector?
No, sir.
Has the property been maintained?
No, sir.
Okay, let's hear from our respondent.
Yeah, for the building.
If I could speak, sir.
Yes.
They had provided a permit, they requested a permit from the city, and it was received to do a maintenance replacement of some sheeting and shingles. A stop work order was then posted because not only did they completely gutted the building, put up new joists, decking, framing around the exterior, all without a permit. This was notice, stop work order was posted not only by my inspector, but also by the city official. Along with that, they still haven't done the other violations with the trash and debris and securing the building. There is also a new violation, of course, issued for work without a permit.
So I have new construction going on, and we haven't rectified any of the problems that we had.
Correct, sir.
We've been dealing with from day one.
Correct.
Okay.
And there's photographs that if you continue to scroll through, you'll see that's the stop work order that was posted. There's trash and debris.
There's a stop work order posted on the new building?
On the building that was just supposed to have some roof repair done to it.
Okay, you telling me, okay, the photograph of the building that appears to be a new building with the stop work order, you tell me that is not a new building?
No, go back one more slide, please. That is the building they were supposed to tarp.
Right.
They got a permit for maintenance, that's what Mr. Hillary mentioned last month's hearing, to do a minor repair of shingles and underlayment. Now, if you go to, this is what they ended up doing.
Is that the same building?
That's the same building where they took off all the siding without a permit. In fact, we took off the whole roof and redid the whole roof structure. Added, as you can see, the new framing all around the building. All of that was without any permits. And then there's the trash and debris that we've been showing throughout this proceedings, these hearings, that hasn't been removed. You can see the openings, and if you go back one slide, you can even see a door is open, and they haven't tarped this roof yet.
All right, and just to bring us up to speed, we have an order entered January 2017, 2024. It said everything was supposed to be, must bring trash and debris, property maintenance, tarp buildings, and secure to city standards by February 7th, and that has not been done.
That is correct, sir.
All right, what say the respondent?
We put in for a permit to redo the roof. Where the top was. We kept putting the top on. That's what exactly we did to the roof. So we got in touch with the city. They told us the language that we had to put in there to be able to get this permit. Why we weren't being permit. Builder had period. And so guys were up on the roof, I was told, and it caving in. And we put in there to the roof and the mate on the roof so we could be able to keep it. And so they went through the building. And so when they went through the building, they did that. And on Monday morning, the contractor and them got with the city to put in more maintenance on there because it was more than just the roof when they came down there. So the roofing company did their part right there, and they pulled those boards off, get the permit. And so once all of that happened, with them trying to get the roof done, they got half of that roof done back on there. But we had to get the rest of the engineering stuff done for the rest of the building. While we were waiting on that, and we're still waiting on that there, they came, told them they had to stop on the roof part to get them planned for the rest of the building. So that's what happened on that part of it.
All right, what's the relief the city's looking for?
City's looking for a fine of $250 per day to a cap of $20,000. That's for not tarping the buildings, removing the trash and debris, and not securing the buildings to city standards. And we also are asking for a compliance date of the main cutoff for the remainder of the violations. Just as a side note, the stop worker work was posted and the permits were canceled for any work that was to be done there, as it exceeded the scope of what they had requested. And we're continuing to receive complaints from the community in regards to the status of this property.
What's the compliance date the city's proposing?
May cutoff,
May?
yes.
What say the respondent to that?
All right. Yes. We just got our site plan approved from the city. So yes, moving forward with that. They gave us 45 days, engineering them, to get engineering stuff to us on these buildings that we're currently working on right now. So that means the permit should be before, since you're saying May. Yes.
Okay, I'm fining the respondent the sum of $250 per day commencing February 8, 2024. And that fine will continue to accrue each day thereafter until the requirements are met, specifically pertaining to the trash and debris, the property maintenance, the tarping of the building, and the securing to city standards. Until that portion is brought into, until those items are brought into compliance, or the amount of the fine has reached the sum of $20,000. And I'm further ordering that this property be brought into compliance by May 8, 2024, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Good luck to you.
Yes, sir.
I'm going to be honest with you. I don't know what's going on out there, because I don't know what I thought was going to be occurring for as long as we've been working with you. This doesn't seem to be happening. I'm not saying it's not due to circumstances beyond your control, but very good. Good luck to you.
Yes, sir. Thank you.
Case number 23, Christina Jones. Not seeing a respondent. What say the city?
A second, sir. This case was opened back, and the owner was first notified on September 20th, 2023. This is for a vehicle parked in the yard, trash and debris, landscaping maintenance. There has been no contact since the last hearing, and no progress has been made. Staff is asking for a fine of $100 a day to a cap of 15.
Noting the absence of the respondent, based upon the testimony of our inspector and the photographs presented, I'm fining the respondent the sum of $100 per day commencing February 8, 2024. That fine will continue to accrue each day thereafter until the property is in compliance or the amount of the fine has reached the sum of $15,000. Case number 24, BMS Holdings, LLC. Anyone here for the respondent? Not seeing a respondent, what say the city?
The respondent was first notified of the violation on October 24th, 2023. Since last hearing, I've had no contact from the property owner. Not only has no progress been made, but the property has deteriorated more. Staff is recommending a fine of $100 a day with a cap of 15.
Noting the absence of the respondent, based upon the inspector's testimony and the photographs presented, I'm fining the respondent the sum of $100 per day commencing February 8, 2024. The fine will continue to accrue each day thereafter until the property is in compliance or the amount of the fine has reached the sum of $15,000. Case number 25, the Seventh-day Baptist Church of Daytona Beach Incorporated. Anyone here for the respondent? Not seeing a respondent, what say the city?
Mr. Coucher, I know this has been going for a little bit. The respondents represented by Mr. Toby Ebbets, I have candy in my mouth.
You what now?
Toby Ebbets, he had indicated that he has a court conflict. You may remember last month we had pointed out, acknowledged that he had received a large number of files relating to the historic information that they believe may possibly have granted them some type of grandfather status. They have kept the pantry closed from the date that we initiated the notification. We have no indication that they, and he said that, and assured that they would continue to maintain leaving it closed and abide by the ordinance until they determine whether or not they have a right to do otherwise. So we have no objection to continuing it one more month to the March for him to finish his review and make a determination of what actions they want to take, if any, or how they want to try and establish, if they elect to reestablish the pantry. But as of the initiation of this case, they have ceased. Once they had ceased operation of the pantry, it remains closed to the best of information from the inspectors. And it's been assured by Mr. Ebbets to me on a repeated basis.
All right, based upon noting the absence of the respondent, based upon the presentation of the city attorney and the magistrate's understanding that the use involved, that being the pantry, will not be utilized while this matter is pending, I will once again continue to the special magistrate meeting of March 12, 2024, the determination of compliance or non-compliance in this matter.
Thank you.
Case number 26, Eric L. Walker Sr. Anyone here for the respondent?
Yes, here on Zoom. Yes. I'm here. Hello?
Yes, sir, we're here. If you would, please state your name and be sworn by our secretary.
Eric Walker.
Raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes.
Thank you.
All right, this matter is here for the imposition of a fine, so let's hear from our inspector. Mr. Bostwick?
All right. All right, respondents was first notified back on May 19th of 2023. Since last October's hearing, one of the structures was removed. I spoke with the owner on February the 8th. The staff requests a fine of $250 a day with a max of $15,000.
Okay, so what is the non-compliance? We still have storage sheds?
Still have those two. We removed the first one. We still have two left.
What was removed?
There's some pictures that would show it.
Okay.
Right there, the first one, the carport was removed.
Okay.
And those
So I have two storage sheds
are still there.
still there, and they were supposed to be gone by February 7th.
Yes, that's what he said he would have done, and that's when he asked for the extension from you back in October.
Okay, Mr. Walker, city wants me to fine you. What do you do about those sheds?
I am trying to have them moved, get somebody to help me move them. First, they had to be empty. It was like 4,000 pounds of storage material that I had hauled to the landfill. So I've been actively working on it. In the middle of this, my son was murdered in West Palm Beach, so I'm dealing with a bunch there also. I'm taking care of it. It's just the couple of times I've had somebody secured to do it, the guy tried to move them without a permit from the county, and I didn't want to do that because they're 12-foot wide, 24-foot long. So they need to be on a truck with an escort in front of them, and I didn't want to, end up with the sheds in the middle of the intersection somewhere. So the problem right now is just securing somebody. I've had like 2 different people fall through, companies. So I'm just trying to find them. They're both empty. The carport's removed. And I just need more time to take care of it.
Well, Mr. Walker, this matter goes back to May of 2023, so we're coming up on an anniversary here.
Yeah. And I can assure you that it's going to be taken care of relatively quickly, but, and I do apologize for not having it completed, but it's not from a lack of trying. Like I said, they were both full with my brother's stuff and mine. They both had to be empty. The carport removed. I'm still working full time with the power company. So, and then I'm dealing with this murder with my son and everything that's gone behind that, financially burying him.
All right, Mr. Walker, hang on a second here. Okay, here's what I'm going to do. I'm going to give you till April 3. That's 60 days to deal with this. You going to have it done by then?
Yes, sir.
Because if you don't have it done by then, you're not going to leave me much choice but to go ahead and grant the fine that they're asking for. I'd like to avoid that if I could.
And so would I.
Okay. All right. I'm sympathize with your circumstances. I appreciate the fact that you've done something. You haven't ignored us completely, but we've got to get it done. So I'll give you till April 3, 2024 to come into compliance or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. And at that point, we'll be coming up to a year, and I'm afraid you probably will get fined if we're in the same boat.
Okay. Well, thank you and Mr. Boswick.
Good luck to you. Case number 27, the Pompey Land Trust dated March 16, 2010, trustee. Anyone here for the respondent? What say the city?
All right, respondent was first notified back on October 23rd of 2023. Since the last hearing, no contact or progress cleaning up the fence line area. Staff requests a fine of $250 a day with a max of $15,000.
How much per day?
$250 a day.
Noting the absence of the respondent based upon our inspector's testimony and the photographs presented, I'm fining the respondent the sum of $250 per day commencing February 8, 2024, and the fine will continue to accrue each day thereafter until the property is in compliance or the amount of the fine has reached the sum of $15,000. Case number 28, Jonathan L. Daughtry. Anyone here for the respondent?
Okay.
Not seeing a
Mr. Vecalja, we're going to request that you rescind the order of noncompliance. There was a tax deed sale.
Are we talking about case 28 right now?
Mm-hmm.
Okay. All right, what's going on?
You want me to finish?
Yeah, go
Okay.
on.
So we had an order of noncompliance, and we had a tax deed sale go through the same day that the order of noncompliance was signed. So we were asking for, and so we're able to recite the new owner.
They actually recorded the tax deed sales of record prior to us recording our
Order of noncompliance.
order of noncompliance. So we proceeded with the case not realizing that had occurred. And that's why we're at this point of imposition of a fine, but we would ask to just dismiss, and we'll go ahead and get with the new owner of the property and have them remedy if necessary, we'll cite them if we need to.
All right, well, based upon the attorney's presentation, I'll go ahead and dismiss case SMG 012410. That dismissal is without prejudice, given that it's my understanding that it will be resumed or refiled as to the new owner.
That's correct.
Very good. Case number 29, Terry Jerome Moore. Anyone here for the respondent? Not seeing a respondent, what say the city?
Our respondent was first notified back on October 11th of 2023. Since the last hearing, no progress in removing the RV or contact. Staff requests a fine of $250 a day with a max of $15,000.
Based upon our inspector's testimony, the photographs presented, I'm finding the respondent the sum of $250 per day commencing February 8, 2024. The fine will continue to accrue each day thereafter until the property is in compliance or the amount of the fine has reached the sum of $15,000. Case number 30, Mohammed Kabaze. Anyone here for the respondent? Not seeing a respondent, what say the city?
Our respondent was first notified back on October 31st of 2023. Since the last hearing, no further progress was made in cleaning up the property. No contact was made. Staff requests a fine of $250 a day with a max of $15,000.
Noting the absence of the respondent, based upon our inspector's testimony and the photographs presented, I am finding the respondent the sum of $250 per day commencing February 8, 2024. The fine will continue to accrue each day thereafter until the property is in compliance or the amount of the fine has reached the sum of $15,000. Case number 31, Samuel F. Postel. Anyone here for the respondent? Not seeing a respondent. What say the city?
Our respondent was first notified back on November 15th of 2023. Since the last hearing, no contact or progress was made. Staff requests a fine of $250 a day with a max of $15,000.
Noting the absence of a respondent, based upon our inspector's testimony and the photographs presented, I'm finding the respondent the sum of $250 per day commencing February 8, 2024, and the fine will continue to accrue each day thereafter until the property is brought into compliance or the amount of the fine has reached the sum of $15,000. Case number 32, Blue Tourmaline Properties and Marie Adonis. Anyone here for the respondent? Not seeing a respondent, what say the city?
Our respondent was first notified back on September 5th of 2023. Since the last hearing, there's been no contact with the owner, no further progress. Staff requests a fine of $250 a day with a max of $15,000.
The notes I have say add Marie Adonis.
I
What does that mean?
apologize, Mr. Vecalja, I was supposed to take that off of there. That was already done last meeting.
Noting the absence of the respondent, based upon the inspector's testimony and the photographs presented, I'm finding the respondent the sum of $250 per day commencing February 8, 2024, and that fine will continue to accrue each day thereafter until the property is in compliance or the amount of the fine has reached the sum of $15,000. That brings us up to lien review number 1, Crystal One LLC. Hugo F. Toloza. Anyone here for the respondent?
Did he appear on Zoom?
Yes, we have,
He's not.
we have negotiated and talked with the request for the lien reduction. It is on lien reduction, lien review 1 and the following. He agreed to, this is for just a partial release of lien, and he's agreed on both of these for $1,250. We have a email from him. He was not able to make it today, agreeing to that amount. And again, that's just for a partial release of lien. The property is cross-encumbered.
Okay, a partial release of lien. So what is the partial release releasing?
It's releasing a property that he owns into land that he's attempting to sell.
So we're releasing the land property?
We're releasing the land property, the land property of this encumbrance.
From this lien?
Yes.
Okay, gotcha. All right. With regard to lien review 1, specifically SMG 02-2021 and SMG 05-22-148, I'm granting a partial release from this lien for the property at 1630 DeLand upon payment of the sum of $1,250 to be paid within 30 days. I am also granting a partial release for the property at 1630 DeLand for the second of these two cases for another $1,250 to be paid within 30 days. So to summarize, 1630 DeLand shall be released from both of these liens upon payment of the sum of $2,500 to be paid within 30 days. Failing that, the full liens will remain in full force and effect. That take care of that?
Yes, thank you, sir.
Lien Review 2, Redesign Enterprise LLC. Is there anyone here for the lien review applicant?
He's supposed to be on Zoom.
It'll be on Zoom. There.
Yeah,
Yes, sir. If you would please state your name and be sworn.
he's the attorney.
I'm sorry, sir, you want the attorney to be sworn in?
Oh, I'm sorry. You counsel for the applicant?
Yes, sir.
All right, if you would then just state your name, please.
Yes. Again, Keith Arago, A-R-A-G-O, with Bogan Munz & Munz, counsel for Redesign Enterprise. Sorry, can you hear me, sir?
Yeah, I can hear you.
Okay, very good.
Okay, have the parties had any conversations regarding resolution of this?
Inspector Garcia, credentials on file. Yes, we have.
Have you come to an agreement?
Yes, sir. We have
What is that?
agreement, and we agreed on reducing the fine down to 5,000.
I'm sorry, what now?
Reducing the fine to 5,000.
Is that agreeable to you, Mr. Arago?
It is agreeable. My understanding, payment within 30 days, sir.
Okay, very good. Then I will adopt the stipulation of the parties to reduce the lien to the sum of $5,000, subject to that being paid within 30 days. If it's not paid within 30 days, the lien, the fine and the lien will remain in full force and effect as is. If you need any assistance with that payment, if you will contact our city attorney, he'll be happy to assist you.
Thank you, sir.
How do I pronounce your name again? Is it Arago?
Arago, like the air.
Okay, very good. All right, well, thank you. And did that cover everything?
Yes, sir.
All right. Thank you. You have a good day.
You too.
I now have miscellaneous business. This poor gentleman's been waiting forever. Doran Neeson, trustee, I assume that is. Yes, sir. If you would please state your name and be sworn.
Doran Nissim.
Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes, ma'am.
Thank you.
All right, let me start with our inspector. What are we dealing with here?
All right. So they are requesting a partial lien release so that they can refinance a property, which will allow them to avoid bankruptcy and also shore up funds to fix some of the issues at this building. So the city takes no issue with that partial release.
So we are waiving the lien, granting a partial release. What are we doing?
A partial release.
Partial release.
Yep.
And what is it we're releasing?
It's the New Smyrna Beach
Yeah, the
property.
New Smyrna Beach, 610 Warren Reed Circle.
Separate property.
So we're releasing this New Smyrna property
Yes,
from the lien encumbrance,
correct. And that's it.
and that's it.
Yes. He still plans on paying our lien.
Pardon?
He still plans on paying our lien at the end. He's not asking for anything else.
Okay, is the New Smyrna Beach property the 610 Warren Reed Circle?
Yes, sir.
And why are we doing this?
We believe it would be beneficial because he currently can't refinance that property, and he wants to use part of the proceeds of that refinancing to satisfy our property. We believe it is in the best interest of the city and him to be able to move forward.
Okay, and I assume you're in agreement?
Yes, sir.
Okay. Then I will grant a partial release of the lien in SMG 0622-164 to release 610 Warren Reed Circle, New Smyrna Beach, from the encumbrance of the lien. Other than that, the lien remains in full force and effect. Did I say that right? Very good.
Thank
All
you.
right, good luck to you.
Thank you.
Thank you.
Okay.
Neighbor Review 1 has rejoined the meeting via Zoom. Please advise as to how you would like to proceed.
Lien review 1.
You just, let him know that we accepted his.
Pardon?
He just wants to know that we accepted our recommendation.
Wasn't he listening to us when we did it?
No, he was off. He just came back.
Yeah,
Okay.
he must have missed it.
Well, if you want to bring him back up, I'll explain it, or tell me what you want me to do.
Mr. Tolozo?
Yes, sir. Is it Mr. Toloza?
Can you hear me now?
I can hear you. Can you hear me?
Yes, perfect.
All right. If you would please state your name and be sworn by our secretary.
State your name.
State your name.
I'm here. Fernando Tolosa.
Raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes.
Thank you.
All right. The inspector told me that the two of you had worked out an arrangement whereby you would pay $1,250 for each of the 2 cases that we're dealing with. And in return for that, we would release the lien, or we would release 1630 DeLand from the encumbrance of that lien. Is that your agreement?
Yes.
That's what we did.
Okay, perfect. Thank you very much.
All right, you have a good day, sir.
You too.
All right, do we have any other business to be brought before the special magistrate?
No, sir. We're good.
If not, we're adjourned.